Hi, it's Gerry Oginski. I'm a New York medical malpractice and personal injury trial lawyer. Today's video answers the question, what questions should you never ask at a deposition? The answer? There is no question that you can't ask at a deposition. There are only two exceptions to that. Number one is if something is privileged. Now, what does that mean? It means if you have a communication, if you talk to your attorney, then the things that are said between you and your attorney are privileged and they cannot ask you about that. What's the other thing? Well, if there's information that is clearly not relevant, that doesn't involve your particular case, can they still ask the question? In New York, the answer is yes, they can, and they're entitled to get an answer. But here's what happens. At the time of trial, the attorney will object, and then the judge will have to decide whether or not the information is related to the issues in the case. And if they are, then that information is going to come in. But for the purposes of discovery, meaning at the time when there's an exchange of information about what's going on with the various parties, what they've said and what they've done, the attorney is permitted to ask you about questions that are totally unrelated, seemingly unrelated, to whatever it is that you're claiming in the case. So, the title is a bit of a misnomer. Questions you can never ask at a deposition. You can ask virtually everything, except for things that are privileged and confidential, and things that are technically unrelated to your case. And that's it for today's video. I'm Gerry Oginski here in New York. Thanks for watching.